Will my green card expire in 2 years? What's a conditional green card? Hi, I'm Shariq and I'm the South Asian attorney. Were you married for less than 2 years when you got your green card? If you answer yes, then the green card that you received is conditional. What's a conditional green card? A conditional green card is just like a regular green card. The only difference is that it is valid for 2 years and cannot be renewed. Does that mean that you have to leave the US after your conditional green card expires? No. It just means that you have to get the conditions removed. So how do you know if you have conditions on your green card? Your green card will have letters CR1 under the category section. A conditional green card is valid for 2 years and cannot be renewed. You must get the conditions removed within 90 days of its expiration date. When applying to get the conditions removed, you must prove again that your marriage is genuine. You can get the conditions removed by filing Form I-751. You must file it within 90 days of your green card expiration date. If you file your I-751 application earlier than 90 days, it will be returned. And if you file it too late, you lose your green card. You and your spouse will file Form I-751 jointly, and both of you must sign the petition. You must submit a copy of the front and the back of your green card. You must also show documentary evidence to prove that you entered your marriage in good faith and that you're committed to living together. You can include things like a mortgage contract or a lease showing a common residence, joint financial records, birth certificates of children, joint tax returns, insurance policies, healthcare plans, purchase of joint property like a car, etc., photos of travel together or at family or social events. Should I include a cover letter? Even though a cover letter is not required, it may be beneficial. For example, the cover letter might clear up concerns about your application and reduce the possibility of any evidence request from the USCIS. In this cover letter, you can also explain why you might live separately or have different last names. You can also use it to summarize your application by providing a list of contents and briefly explaining each item. Most I-751 petitions will be approved. However, USCIS will only accept your application if you provide enough documentary evidence to prove to the USCIS that you entered the marriage in good faith. If you initially entered your marriage in good faith, you can request a waiver of the joint petition requirement. This waiver may be based on 3 grounds. Your marriage has been terminated by divorce, you've been battered or subjected to extreme cruelty by your U.S. citizen or LPR spouse, or termination of your green card and deportation would result in extreme hardship. You can request the joint petition requirement to be waived if you entered your marriage in good faith, but it's ended in divorce. It doesn't matter who was at fault or who started the divorce proceedings. A good faith marriage means that you entered the union intending to build a life together. You did not enter it only to get a green card. You can apply for this waiver if you've separated or either party has filed for divorce, even if the divorce has not yet been finalized. USCIS will issue a request for evidence or RFE and grant you 87 days to produce the final divorce decree. If your divorce is finalized within that period, USCIS will decide on your waiver. However, USCIS will deny the waiver and terminate your green card if the divorce is not finalized within 87 days from the RFE. You can amend the petition and file under the other 2 waivers if your conditional green card is near expiration, but you don't believe that the divorce will be finalized within the allotted 87 days. However, the reasons must be genuine. So what if you file the I-751 petition jointly, but you've separated from your spouse or have filed divorce proceedings? Well, the good news is that USCIS will not deny your request to remove the conditions just because you've divorced or separated. Again, you're going to be okay if you enter the marriage in good faith. Okay, so now let's talk about the other 2 waivers. You can also request a waiver of the joint petition requirement and file separately to remove the conditions on your green card if you or your child have been victims of battery or extreme cruelty. So what acts can be considered battery or extreme cruelty? Any act of violence or forceful detention resulting in physical or mental injury. Even the threat of violence is considered violence. In your petition, you should have a detailed statement of the act along with evidence. This evidence may include restraining orders, affidavits from domestic violence shelters, photographs, and medical reports detailing the injuries. If you're finding this video helpful, please like and subscribe. It really helps my practice grow. You can also request a waiver of the joint petition requirement based on extreme hardship. Now, this hardship can be to you or your children. USCIS will only consider the extreme hardship factors after you receive the green card. These factors can be personal or public. However, note that the hardship must be of an extreme nature, which means that it is something more than usual. If your spouse dies before you remove the conditions on your green card, you'll obviously not be required to file a joint petition. Again, if you enter the marriage in good faith, you can file the petition separately. When filing the petition, you should submit a copy of the death certificate with evidence of bona fide marriage. Your dependent children may be included in your removal petition, whether you file it jointly or request a waiver for the joint petition requirement. However, your child must have been granted a green card either at the same time or within 90 days of your green card. Otherwise, they'd have to file a separate petition. They would also have to establish that you entered your marriage in good faith. If you can show that you have a good cause for filing a late petition, USCIS will allow it. You must state in writing why you didn't file the removal petition before the end of the conditional 2-year period. These reasons may include hospitalization, long-term illness, death of a family member, the recent birth of a child, etc. Remember that USCIS will only accept your application if you provide a written explanation showing good cause for not filing within the allotted time. So how late can you file the petition? With a written statement of good cause, USCIS will likely accept your application up to a few weeks after the deadline. However, if your application is a few months late, USCIS will meticulously probe your reason for the delay. You can either type your answers on Form I-751 and print it out, or print out a blank copy first and fill it by hand using black ink. Once you've completed your form, you must mail it to the USCIS. The mailing address varies depending on where you live. I'll include a link to the address information page in the description below. The filing fee for Form I-751 is $595 currently. In addition, there's an $85 biometric service fee for each person included on Form I-751. You can pay these fees with a money order, personal check, cashier's check, or a credit card. The check must be payable to the U.S. Department of Homeland Security. After you file Form I-751, you'll get a receipt notice in the mail. This notice is called Form I-797. The validity of your green card can be extended up to 2 years using this notice. The processing time for the I-751 petition depends on the USCIS office processing your application. Different offices will have different processing times. Sometimes this wait can be up to 3 years. I'll include a link to the current wait times page in the description below. But the good news is that your current green card will remain valid until the USCIS decides on your petition. This means that you can travel and work as you did before. However, before you travel, you can get an extension stamped on your passport. You can contact USCIS and request an appointment to do so. Please make sure that your application is complete before you file it. Otherwise, USCIS will send you a request for evidence or RFE, and this will further delay the process. You'll be eligible for naturalization 3 years from the date you initially receive your green card if you're still married to your U.S. citizen spouse. However, the USCIS will only approve your citizenship application once it approves your I-751 petition. You and your spouse may have to attend a USCIS interview to remove the conditions on your green card. However, if the evidence of a legitimate marriage is strong, the USCIS may waive this interview. After the USCIS approves your application, your conditional status will be removed. You'll receive a written notice of this decision. You'll also receive a new green card valid for 10 years. If you have questions, please contact my office. If you found this video helpful, please like and subscribe.